Hi, everyone. I hope we are live on Zoom. Welcome so much. My name is Debbie Schrager. I'm the director of the Supreme Court Institute here at Georgetown Law. And I'd like to welcome everyone who's here in the courtroom and watching this program virtually. The Supreme Court Institute is honored to co-sponsor this program with the South Asian Bar Association of DC, the South Asian Law Students Association, and the Dharmic Law Student Association. Founded almost 25 years ago, the Supreme Court Institute is best known for our report program, which taps into the expertise of faculty and outside practitioners to prepare counsel for oral argument before the Supreme Court. SEI offers its reports as a public service and at no charge and irrespective of positions taken by counsel, reflecting a core commitment to the quality of Supreme Court advocacy in all cases. We also sponsor educational programs such as this one, focusing on the Supreme Court, the work of the Supreme Court and cases of the court past and present. I would like to thank this very distinguished panel. I realize I'm not standing back far enough to be seen. I just realized that. I apologize virtually on Zoom. As I was saying, I would like to thank this distinguished panel for participating in this event and also thank SEI Assistant Director Cal Goldie and Georgetown Law Event Coordinator Claire Sanfilippo for their invaluable help handling many logistics. Just a small bit of housekeeping. I would like to remind everyone in the courtroom that this event is being live streamed on Zoom, and we will post a recording of the program on the law school's YouTube channel. I also ask that you refrain from eating and drinking anything other than bottled water while you're in the courtroom. We like to protect this carpet. I am now pleased to introduce our moderator for tonight's program, especially pleased because he is a JD candidate here at Georgetown Law Center. Ashwin Ramaswamy, I hope I said that right, close enough, is from Johns Creek, Georgia, and holds a BS in computer science from Stanford University. He works at the intersection of technology, law, and policy, and his interests include digital humanities, religion and spirituality, and the South Asian American experience. At Georgetown, he is president of the Dharmic Law Student Association, which comprises students from the Dharmic traditions, religious, spiritual, and philosophical traditions that are centered around the concept of Dharma, including but not limited to Buddhist, Hindu, Jain, and Sikh traditions. Equally impressive is that this program is happening completely at Ashwin's initiative and leadership, which is no small feat for a busy law student. When he asked if SEI would help host the event, it was an immediate yes. I am personally grateful to have played a small part in facilitating this important conversation.
Thank you so much. I very much appreciate all the support that SEI has given to make this event a reality, in addition to Salva DC as well, and also the student orgs Salsa and Delsa as well. This event would have been possible without all of you. So I'm going to start with a quick introduction to who and what we're talking about, and then introduce our panelists here. So we're talking about Dr. Bhagat Singh Thind and his story. 100 years ago, in 1923, the Supreme Court took away American citizenship from an extraordinary man named Dr. Bhagat Singh Thind. He was many things: a Sikh-American, a UC Berkeley graduate, an independence activist for India, and also an American war veteran. He still had his citizenship revoked by the Supreme Court. And this is because at the time, American naturalization law only allowed free white persons, whatever that means, and those of African ancestry to become citizens. But what about Asians and Indians? Were they white, black, or neither? They didn't really fit into this whole dichotomy. So that's what we'll be talking about today, and the implications of that case 100 years later for how we think about everything we're working for, whether debates on race, caste, what's the role of spirituality and religion and politics and all of those things. So I will introduce our distinguished panelists here. So first introduce Mr. Sim J. Singh Atariwala. He's the Senior Manager of Policy and Advocacy at the Sikh Coalition. His work focuses on grassroots and national advocacy against various issues such as hate crimes, workplace discrimination, and racial profiling. He has testified in Congress, quoted in various publications, and presented remarks in national conferences around the issues which he and his organization advocate from. He's also a graduate of Georgetown Law. He holds his master's in law from Georgetown. And he also is an active member of the South Asian Bar Association of Washington, D.C. So thank you for being here.
Thank you, Ashwin.
Yeah. The next panelist is Professor Shirali Munshi. She's professor of law at Georgetown University. She earned her JD from Harvard Law School and a PhD in literature from Columbia University. Professor Munshi has studied and done a lot of scholarly work on Thind, in this case, extensively, and has an article on the contemporary relevance of Thind in the Ethnic Studies Review. Her areas of scholarly interests include property law, immigration law, and critical legal theory. Her writings appeared in various places such as the Yale Journal of Law of Humanities, the American Journal of Comparative Law, and Harper's as well. So thank you for being here, Professor Munshi. Finally, we have Mr. Tejinder Singh. He's a go-to appellate advocate for plaintiffs, including various folks, including whistleblowers, victims of terrorist attacks, and civil rights victims of civil rights violations. He's done, before joining Sparacino PLLC, where he is now, he was a partner at the elite Supreme Court, an appellate litigation boutique, Goldstein and Russell PC. He made history as the first turban Sikh to ever argue a case before the Supreme Court of the United States. In fact, he's just finished arguing the Supreme Court case yesterday. And yes. He's also developed a very deep understanding of the law. And I've heard that Supreme Court Justice Elena Kagan has described him as an awesome lawyer. Thank you for being here. All right. So I think let's get started. So I wanted to see if we could first start with a just an introduction as to what is the whole case about? What was kind of the main issue in the case before we start digging deeper into it? I was wondering if Professor Munshi, if you could talk a bit to that.
Yeah. Okay. So this case, the Bhagat Singh Thind versus the United States, was decided in 1923. So at that time, the question that the court had put before itself was whether the court's language, a high caste Hindu from Punjab, was racially eligible for citizenship, right? Because this citizenship at the time was restricted to free white people. So the Naturalization Act of 1790, one of the first acts of a revolutionary Congress was to restrict citizenship to white people, right? After the Civil War, Reconstruction, that language was amended to extend citizenship to emancipated Africans. So it was the language of that restriction was amended to embrace descendants, African Americans and descendants from of African Americans, something like that, right? But the point is that language was adopted, right, explicitly to exclude Asians from citizenship, rather than simply strike out the racial qualification for citizenship, right? The purpose was to sort of exclude Asians from citizenship. But the Naturalization Act posed relatively few hurdles to immigration until the turn of the 20th century, when a greater diversity of immigrants were coming to the US from, the sort of darker parts of Europe, and also Asia and Arabia. And then under the pressure from various labor unions and others, courts started adopting a more restrictive interpretation of white, right? So before Thind, a lot of Indians had been naturalized, right? The Naturalization Act didn't put any barrier, right? But, during this kind of moment of heightened nativism, courts are adopting a more restrictive interpretation of white. So before Thind comes before the Supreme Court, the Supreme Court also decides another case involving a Japanese immigrant named Takao Ozawa. Okay, and this this particular fellow, right, was arguing that he was qualified for citizenship because actually his skin looked relatively white, right? He said, if you sort of lift the sleeves of my jacket, you'll see that my skin is relatively white. But the court rejected this argument, instead appealing to a kind of racial scientific language, and argued that, you know, what we mean by free white people are Caucasians. Okay, so then Thind came along and said, actually, under race science, you know, evolving race science, I am from the Caucasus, descended from the same places as Europeans in the United States. And then at that point, the court rejected the argument, clarified its holding to say, what we mean by Caucasian is what the average well-informed white American means by Caucasian, right? So part of what's astonishing about this decision is that the average well-informed American becomes invested with this power to determine membership, right? Citizenship and belonging within a kind of national family. And so, you know, so this is what the case has largely come to stand for. I think the racial inscription of difference, right? When it comes to the Japanese, Indians, but perhaps Asians more broadly, right? And the racial disqualification from citizenship, right? I think we can complicate that narrative, right? But that is what the case, I think what the language of the case does.
Yeah, that's great. And, oh, go ahead. Yeah.
No, I was going to say that that's exactly right. The really fun part of the case, I think, is when in Ozawa, you know, the court says, I actually love the actual language. You know, they say manifestly, the test afforded by the mere color of skin is impracticable because it differs greatly among persons of the same race, even among Anglo-Saxons, ranging by imperceptible gradations from the fair blonde to the swarthy brunette, the latter being darker than many of the lighter hued persons of the brown or yellow races. You know, so like there's this whole description, like you can't tell by looking, you know, you gotta go a little deeper. And then when someone says, okay, I look deeper, it turns out I'm white, they're like, no, we looked at you. You know, definitely not. And so it's an interesting flip-flop that sort of draws into focus what's going on. Another interesting fact is that both of the decisions are written by the same justice, George Sutherland, who had just been appointed to the court and who was himself actually an immigrant. He was born in England. So that's, you know, nice move from his fellow immigrant.
Yeah, I was curious, Mr. Singh, if you could talk more about the composition of the court. At the time, there was Sutherland, there was Taft. How did that kind of affect how the court thought of things? And maybe, you know, how is what they did there still maybe good law today? And how does it affect how we still think about, you know, legal categories today?
Sure. So the Taft court it's actually a pretty interesting time in the court's history. The Chief Justice was Taft. And Sutherland was newly appointed, along with a few others who, there were 4 justices, quite conservative, who came to be known as the Four Horsemen. And what they became famous for was striking down New Deal legislation as Democratic administration tried to sort of get the economy on their feet. But at the time, an important fact about how this case arose is it wasn't just the courts adopting more restrictive interpretations. This appeal happened at the behest of the US federal government, the executive branch. So they had said, you know, you cannot be naturalized. The US district court actually ruled in Thind's favor, said, yeah, no, that's fine, he's totally white. And then they appealed to the Ninth Circuit. And then the Ninth Circuit got to certify the question to the Supreme Court. So it wasn't until 1925, a couple of years after this case, that the Supreme Court gained a lot more control over its docket through the certiorari process that is now the most common way. You'll often hear about how the Supreme Court only hears a handful of cases. And you know, that process, though, was not always the case. There were more ways to get a case in the Supreme Court back in the day than there are now. And so one of those ways was that this just got sent up. And so a few things had to happen for the case to get decided the way it did. You know, the executive branch had to take this position, and then, you know, district court ruled, and then they had to appeal. And so these decisions were being made at the highest levels of the executive branch, and then they were getting to the Supreme Court kind of by operation of this process. It's possible that they wouldn't have made it to the Supreme Court later under the certiorari criteria, but then again, if the government wanted it up, it probably would have gone up. In terms of how they're looking at the statute, it's a really interesting question. You know, if you look at what they did, they said, when we read statutes, we generally look at what the words meant to the people who enacted them. And I would say that that is still an accurate description of how the Supreme Court mostly does statutory interpretation. They look at the text, they try to figure out the plain meaning in the eyes of the people who enacted it, and then they apply it to the facts that are before them. And candidly, I don't think that they were likely wrong to say, when in 1790 they said free white persons, they didn't mean this guy. That's probably accurate. Maybe they weren't thinking about him, but they probably didn't mean him. A really interesting contrast point is a case that I always think about when I think of this case is this recent decision in Bostock versus Clayton County. So this was about whether Title VII of the Civil Rights Act, which among other things prohibits discrimination on the basis of sex, also applies to sexual orientation, right? And Neil Gorsuch wrote this opinion, the gist of which is like, look, I know that in the 1960s, nobody was thinking about this and thinking that they were actually banning discrimination on the basis of sexual orientation. But I read the words and they say what they say, and this is how it works, and it applies okay, right? And so that's actually an example of a case that uses very similar principles of statutory interpretation, but comes out flatly the other way, right? You would sort of like, I actually view the plaintiff's argument in Bostock as being very similar to the argument that was made in this case, but rejected. And you could ask whether what you're witnessing is an evolution, a more sort of principled approach to statutory interpretation, or what you're witnessing is just a bit of variation in outcomes, because of course, in Bostock, there was a dissenting opinion that was like, no, they weren't thinking about this at the time. So maybe that case is a blip, maybe it's a change, but we'd have to wait and see. But I think it's all really interesting because a lot of the same principles are still being applied in kind of similar ways.
Makes sense. And Mr. Atrewal, I wanted to ask you about, given kind of Thind's experience and, with the legal system and, as a Sikh-American, I'm curious, how does that transfer to how Sikh-Americans operate today in terms of your own advocacy and how you're thinking around those kinds of things? What continuities are there? Maybe what differences are there?
Yeah, I think similar to Thind's case, he's using the existing legal frameworks and structures to his advantage, right? And so one could argue that he took some pretty bad positions from, I guess, a spiritual standpoint. Trying to argue that he had a repulsion to marriage of a Mongoloid woman to basically appeal to the justices that he was white. And I don't know if we would agree with that kind of argument in today's environment, if that were to be made, but he was working within the structures that he had. There was no solidarity movements. There was no South Asian Bar Association. There wasn't this kind of infrastructure he could tap into that he could really fight against the system. So what he tried to do is exploit the current law using the Ozawa case pretty much to his advantage, and it didn't really work out as I think that they imagined. What's really funny is that Bhagat Singh Thind also served in the US Army as a bearded and turbaned Sikh soldier. And that wasn't an issue back then, but then in the 1980s, the Reagan administration decided that religious articles of faith were no longer allowed in the armed services. And so Sikhs were not allowed to serve in uniform with their articles of faith. This also affected Jews, Muslims, many other religious minorities. And we've had to essentially litigate those kinds of issues. And we are still litigating today against the Marine Corps on this very right to allow Sikhs to serve in the uniform. The US Army has allowed it after we sued and were successful in that litigation. We continue to see employment discrimination issues. We continue to see PPE, for example, has become a hotbed issue for our community where we're not allowed to be employed in certain positions because you can't have a fit seal test for an N95 mask. So doctors, first responders, and the like were basically told to shave which was a sincerely held religious belief, or be fired. So it's really just choose your religion or choose your job. And that's really problematic. And it doesn't just impact Sikhs. I mean, we've got racial issues with that as well. There's a painful medical condition that's involved with that affects a lot of Latino and Black men. And so we're accommodating one group of people, but we're not accommodating another group of people who just on the basis of their faith are being told that like, no, you can't do that. And so we continue to see these kinds of systems that we have to work in, but it's just really interesting that the Bhagat Singh Thind case also shows us that immigration isn't, I think, or citizenship is not a concept that we can take for granted. And I'm sure we'll get into that later in the discussion. I don't want to get ahead of that, but I'll just leave those remarks there.
Yeah, it makes a lot of sense. And I think just to build on that point, like about citizenship and thinking about colonialism, immigration, how does this all fit in with maybe what was going on at the time? So we know, for example, Thind was heavily involved in the anti-colonial movement. He was working on behalf of Indian independence. So I was curious if Professor Munshi, you can talk a bit more about that and how that relates to what happened in this case.
Yeah, and I think, I think that, on an occasion like this, where we're sort of commemorating the 100-year anniversary of this case, and when maybe most of us are sort of lawyers, I think it's important to keep in mind, or to be sort of like vigilant about what becomes visible through the language of the case itself, which is really limited to the construction of racial legal categories. And I think that's a lot of the way in which this case has been sort of written about within the legal discourse, right? But it's worth recognizing what that project eclipses, right, about this particular history. So as you mentioned, Thind was part of this radical anti-colonial labor movement, anti-colonial, anti-capitalist movement. And it was really that radicalism, right, that form of political dissent that brought him to the attention of the federal government, and not just the federal government, also British spies, right? Who recognized the threat that this kind of anti-colonial, anti-capitalist radicalism presented to a project of settler colonial capitalism, right? So just some background here. So Thind came in the early, he came 1913, something like that. There's a brief period when a few thousand Indians are coming to the US. And they're mostly laborers who are finding work in the West Coast, kind of filling ships' manifests after Chinese exclusion. So, right, just doing the work that other Asians had been doing before Chinese exclusion. And then a number of them also come as political exiles, already active in an anti-colonial movement, right? And part of what's extraordinary about this Ghadar movement is there is this unlikely coalition between these these laborers and these students, and some of them are student and laborers, like Thind himself. So as you mentioned, Thind goes to University of California and becomes part of this kind of like group of political activists. And what these guys are doing is really synthesizing the kind of anti-racist politics, because they recognize that they are subject to racialized discrimination, and also a kind of labor politics, right? Recognizing that their colonial status also renders them more vulnerable to exploitation, right? And so again, so it's Thind's involvement in this Ghadar movement. He's speaking across the Pacific Northwest, organizing laborers, right? Circulating it's like a newsletter, the Ghadar newsletter, which circulates all over the British Empire, right? Sounding a call for, embracing a kind of anti-imperial politics. And it's this kind of involvement in this, radical heterogeneous movement that really is the menace. It's not his hue, right? So as much as this case is sort of like remembered as a case, I think, about his hue, right? I think what's worth thinking about is the way in which this kind of anti-colonial politics becomes eclipsed by the language of the case, and perhaps like a kind of like anti-racist politics that sort of dominates our thinking about some of these histories now, right?
Right. I think it's also another really interesting part of the case is, as Dr. Well, you mentioned a bit about caste, right? So he mentions that he argues he's Caucasian because he's a high caste of full Indian blood, and there's a pure ancestry descent there. And I think, to me, it's just really fascinating how basically in American law, we have the idea of caste for over 100 years, like, written into the Supreme Constitution. So it's as much as it's maybe, a concept that we associate with South Asia, it's also very much an American concept, and kind of forms the, cornerstone of a lot of our law in terms of who is white and who isn't. So I'm kind of curious, how is this like relevant to today's we have today, whether that's, issues to, combat caste discrimination or, issues around racism. How do we kind of think of that legacy when we're kind of doing the advocacy we need to do today? So wondering if Mr. Adhirwala, you could start on your end.
Yeah, I think, the arguments over race and caste highlight the complex intersectionality, at least for South Asian communities, I think. There's a lot of ways that those categories have been used to define and marginalize certain communities, and that's deeply problematic. And I think that the conversation that Mr. Singh has talked about and Professor Munshi is that there's this reminder here that in the case that the idea of race is, some people view it as a biological or genetic category, but not under the Supreme Court interpretation of that. They're essentially redefining what it means to be white. And they're using that, we saw this in the Ozawa case and the Thind case to justify that kind of argument. Then also, I think, was the evidence that he was part of the Ghadar Party was being used in that case specifically to say that he wasn't allowed to be a citizen. And what's interesting is that the 1906 amendment to the Naturalization Act had changed citizenship to reflect the challenging beliefs of what it meant to really be an American. For the first time, the eligibility actually became dependent on the evaluation of an individual's personal beliefs. So it's not just residence or willingness to take an oath of citizenship. If you were a pacifist, if you were a conscientious objector, an anarchist or a polygamist, you basically could not qualify for being a citizen. And I think that the Ghadar Party was being used essentially as evidence to preclude him from being a citizen. But what's really interesting though is, let's look at the opposite side. If he faced deportation, what would happen to this individual? Like many individuals, they would likely face potential execution for their involvement in the Ghadar Party, because that's pretty treasonous according to the colonial empire. So there was a lot riding on the line for, I think, Thind. And so he had to argue to basically avoid death. Overall, I think the case documents show that social justice and equality in the United States need to continue. And we have to find ways to deconstruct intersecting systems of race and caste and other forms of oppression that continue to shape our lives. I mean, we can look at what's happening today, I think, as potential echoes of the Thind case. After the Thind case, many Indians who gained US citizenship were actually stripped of their citizenship. And the Department of Justice then initiated a bunch of denaturalization proceedings against about 69 people, mostly Sikh men at that time, dispossessed them of their land and leases. And what's also just kind of interesting in some of the history around this is a lot of Indians at the time married US citizen women. And if their men were denaturalized, that meant that also the women were equally impacted and they were rendered stateless. Even though they were born in the United States, they might have been white women, it didn't matter. And so we've just kind of seen this targeting against the various communities. And today, I think that legacy of insecure citizenship remains alive and well. In the 1946 Luceller Act, we saw the quota of up to 100 Indian immigrants in citizenship for resident aliens, and Indians were barred from citizenship unless they were born in the United States, right? In the Obama administration, we saw denaturalization tools, and the Trump administration took this to a new level. In 2018, the Department of Justice launched this Operation Janison's Second Look, and basically targeting South Asians. And when you dig into the case, you see a troubling pattern of immigration officers accusing individuals of using their nicknames for alleged immigration fraud. With Singh and Kaur, common law's name for Sikhs, a lot of mix-up happened because of the case files not differentiating between people, multiple fingerprints being digitized for one person, for example. And it's just kind of, we see this pattern, and we saw what happened in Operation Janus. They scaled up to 100,000 potential flags, and Second Look added about over 700,000 flags for individuals for potential citizenship revocation or denaturalization process. it's kind of hard to also just ignore the Muslim ban in 2017, where we saw the intersection of race and religion start to impact who was being allowed into this country. And I think it just kind of reaffirms, who we want to see, who is considered an American. There's this perpetual foreigner myth within our communities that's deeply troubling.
Yeah, well said. So I wanted to also, I wanted to ask you, Mr. Thind, about, thinking like you were the first turban Sikh to ever argue a case before the Supreme Court. So you're very much a trailblazer in many aspects. Can you talk a bit more about the kinds of experiences and challenges which you have faced in the legal profession, and maybe how this experience of then is a continuity to that, whether that's what you're facing or you're seeing the community face, whether it's immigration, trying to break into certain kinds of positions. How do you kind of deal with that?
Sure. So this is a complicated subject because the issue doesn't only play one way. There is a sense in which I think being a member of a very visible minority group is a substantial advantage. If you are good at your job, you are a very memorable face. And you can leverage that, and you can also help other people very easily just by being good at what you do. It's a wonderful way to lift folks up, even people you've never met. You can do them a lot of good just by doing good work. In another sense, it's a disadvantage, and especially I think, or maybe it's a disadvantage you can turn into an advantage in the field of persuasion. So let me talk about persuasion specifically, because that's what as advocates we do. It is almost impossible to get in an argument with a person and change their mind, right? If you and I get in an argument and I say you are wrong and I am right, and you should believe what I believe and stop believing what you believe, you will likely become defensive, you will stop listening, you will not change your mind, right? The much better way for me to convince you of anything is to actually convince you that what you already believe is in fact what I believe, right? And so to try and build a base of empathy so that my position feels natural and intuitive to you, not something that I can bludgeon onto you, but something that you embrace and believe you always embrace. Now, this is not easy to do. And so a lot turns on whether you have a natural foundation for empathy, right? So I'll take us back a few years. When I was arguing my first Supreme Court case, everyone only really cared what Justice Anthony Kennedy thought, because in any case that was going to be controversial, 5-4, he was overwhelmingly likely to be the vote in the middle. And so like Kennedy whisperers were the most valuable people in the entire Supreme Court bar. And if you asked me, what does your background and experience do to enable you to persuade Justice Kennedy? The short answer would have been almost nothing, right? There was very little about my life that was similar to his life, other than like we both lived in California and we both did law stuff. There was very little to draw upon. The only thing that I guess I did have to draw upon that maybe other people don't is I had an acute knowledge that I didn't have that foundation and that I would have to build it. I wouldn't say artificially, but I would say through study and through work, right? It wouldn't flow naturally from my genetics or my upbringing. It would come from trying to do this project quite intentionally. And so when I say it's a disadvantage that can be sort of judo flipped into an advantage, that's what I mean. I think I started at a real natural disadvantage for persuading any member of the Supreme Court that they think what I think, because I did not come from the same high school or the same, general background. I'm the first, first generation immigrant, first person in my family to ever do anything law related. And so for me, it was my awareness of that gave me the ability to launch a career that made sense by saying, okay, well, now I have to sit down and I have to read everything that you read, and I have to learn how to think like you. And in some senses, it's not so terribly different from an effort to pass as white, right? Which was what you saw in 1923, right? Yeah, I'm white. It's not so different. right? It is suspend your own upbringing, suspend your own perspective, replace it with the perspective of the person you're attempting to persuade, and then see if your arguments work, right? And I think what's a nice role that people like us can play is we can act as translators and bridges, right? Just as anyone who is bilingual can take folks who can't communicate and enable them to do so. And so I think that a lot of the value we can add is in going out into the world, finding people who could not talk to the Supreme Court and doing it for them, because we can understand them and we can understand the justices and we can have both of those conversations. So I tend to view my role as almost like that of a translator or a conduit to bring perspectives that I can understand but the justices cannot, and then cast them in a way that the justices can understand them. So that's a part of my practice, and not just the Supreme Court justices, but like other courts too, right? I work in a bunch of them. But I think that that's how I would put it, that there are ups and downs to this life. But once you understand the project, it's pretty fun.
Wondering if Professor Munshi would also want to talk a bit about your experience in academia, just a bit briefly about how it's been as a South Asian, and
I'm speaking in the place of my employment. I'll tell you, like, a pleasure I take is teaching students, and I see a lot of my students here, and you were in my first Asian American Studies class. Some of you were in the same class. So part of what I'm interested in with something like this case is introducing students to a history that I know many of us have been starving for. It wasn't until graduate school until I encountered this case. You mentioned it wasn't until relatively recently that you sort of encountered this case. And so I think, that's something that I'm interested in doing. And then I just wanted to say also, I think it's worth also, as much as I think we talk about, and we can recognize the continuities between the persecution that Thind endured, right? And the through lines to today, right? I think we can recognize some of the ways in which that case remains relevant to the way in which many South Asians, Indians are Indian adjacent, right? Or South Asian adjacent are racialized, right? I think we recognize that. I think it's also worth recognizing how many of us are not entirely the inheritors of Thind, or not really the inheritors of a legacy of Asian exclusion, but also the beneficiaries of the Immigration Act of 1965, right? And so we have, the story of my parents' immigration to the US is not one of exclusion, right? It's not one of racialized exclusion so much as it is selection, right? And I think it's worth recognizing then the ways in which Asian Americans, especially, like those of us who are the children of the 1965 Immigration Act, the way Asian Americans are kind of continuously being repositioned within a kind of ever-shifting landscape of racial neoliberalism, right? And I think what I want my students to appreciate, right, is not just the kind of like inheritance of racialization or racial inscription that this case stands for, but like, the political excitement that galvanized Thind and others of his generation. So part of what was also extraordinary about the Ghadar movement was drawing lines of connection across, lines of racial difference, right? So workers organizing with students, but the Ghadarites were involved in many kinds of radical movements taking shape, or learn from and in conversation with Irish Fenians and Mexican revolutionaries and international socialists and so on, right? And drawing lines of connection beyond sort of, categories of race, right? And I think that is something that I hope, those of us who have been the beneficiaries of the 1965 Immigration Act are kind of aware of, right? And that we have then obligations to other communities who perhaps are more vulnerable to exclusion than Asians, or at least a certain caste, right? Certain caste or class of Asian Americans have been lately, right?
Thank you. So I wanted to also just emphasize when when Mr. Singh was talking about, trying to find common ground on the other side, one thing that's really, I think, interesting about Thind in his life is also his religion and spirituality. So after he lost his Supreme Court case, he stayed in the U.S. He had spent the next 30 years or so actually traveling around the country, giving lectures in like packed lecture halls around Sikh spirituality. And in fact, I actually have some books here, which Dr. Thind's son, David Thind, was so kind to send me these books. So you can see these are all books around, kind of empowering people, thinking about, what is the radiant road to reality? How do you find happiness in this life? How do you really kind of find common ground with others? And it's not just, maybe finding kind of that strength in spirituality. So in that vein, one of the things he said in one of his books is that he envisions a society which without any routine or superstition, with no purdah or caste, no pariahs, no injustices. So I'm really curious, starting with you, Mr. Atariwala, how does your own faith kind of inform what you're fighting for, and what role do you think religion or spirituality has in this kind of activism or making the world a better place?
I think is similar to the stories that were shared earlier by Mr. Singh and Professor Munshi. We're often expected to be the role models in these professions, right? A lot of us have just kind of been able to take advantage of the 1965 Immigration Act. And only recently have we been able to start breaking these ceilings. To Ginger speaking at the Supreme Court, that was like a historic first for some of our communities. We just recently heard of a Sikh serving on the Supreme Court as a clerk. A big law, American 100 law firm, only within the past 20 years did we see someone attain partnership status. So in a lot of these spaces, it's new for us. But when it comes to our faith, I think the role of religion or spirituality in activism and advocacy can be really complex and multifaceted. On the one hand, religion can provide a powerful source for inspiration for us, motivation and moral grounding. But then we've also seen, I think, some troubling narratives around religion being used to divide communities. And we've seen religion also been used as a tool to justify and perpetuate systems of oppression and inequality. And that can be really problematic. But throughout history, I think we need to look back and figure out a better way. And the personal beliefs versus the institutional beliefs can sometimes diverge. Ultimately, the role that we take at the Sikh Coalition is to make sure that we do no harm to others, other communities specifically, when we're advocating for religious rights. And so we view this as a civil rights issue, not a religious rights issue. And for example, when we litigate cases, we want to make sure that religious liberty arguments are not being used as a sword to discriminate against communities. Specifically, we've seen the troubling pattern of LGBTQ communities being disenfranchised by religion and the law. And that is not something that we think spiritually aligns with some of the faith practices for the Sikh community. And, I think that there's a lot of work to be done here on that particular issue.
Professor Munshi, do you have anything to add on that in terms of thinking of spirituality? Good. What about Mr. Singh?
Yeah, I'll take a slightly different angle on it, which is, and this is speaking mostly to the students here, whether you are a religious person or not, it's quite common, I think, for people to speak of like having a soul. And as you figure out what you want to do with your lives and your legal careers, I would advise that you don't do things that crush your soul. Seriously, I encounter in my day-to-day tons of folks who I think are perfectly lovely human beings. And what they do for a living is make sure that class action arbitration waivers are enforced to the fullest possible degree, right? Or make sure that Exxon makes as much money as possible. And then they go home and they're like, I feel like my soul has been destroyed. And I'm like, yeah, well, you should maybe think about some of your choices. And they're like, but I have law school debt. And I'm like, yeah, I get it. So anyway, you're gonna have to figure this out for yourself. But I will say that, like, you know, for me anyway, to the extent that spirituality and religion and values have played a role in what I do law-wise, it's done a lot to shape the kind of work I like to do, the types of people I like to represent, and so the career that I wanted to build. You know, that doesn't mean I'm standing up and like making religious arguments. I seldom am. You know, every now and then I'll write an amicus brief or something, but like that's not the mainstay of my practice, is religious issues. You know, as I said, my principal job is to like channel the perspective of the people I'm trying to persuade. But as you try to reconcile whatever set of values you have with what you do for a living, it's important to come up with a reconciliation that feels authentic. I feel like the people who are the saddest in the legal profession are the ones who fail that task, who have a really deeply lovely set of values, and then who go and do work and who try to convince themselves that there's no conflict and fail. Those are the ones who I find who find themselves in crisis. So either get really good at convincing yourself that you're the good guy, you know, or actually be the good guy. Those are the two paths to happiness in this line of work.
Thank you. So I think finally we're going to do some closing remarks, and then we'll have some time for Q&A as well. But I want to just get from each of you maybe just like a 1 minute like thing as to kind of looking forward. You know, how do we reckon this history? Kind of what's kind of the takeaway when we think about this case? How should we think about it? And is then really our history, or or is it more complicated than that? How can we use this as the best way to deal with the problems we're facing today? Professor Munshi, want to go first?
Yeah, and so I think I can, as I sort of suggested, and I think some of my last remarks, like I think when we're thinking about how to remember a case like this, right, I think it would be a mistake to use kind of victimization of Thind to affirm something about a kind of like identity forged through victimhood or something like that. And the part of the legacy of Thind that I still find really exciting, right, is his own involvement with this Ghadar party. And maybe later in his life he sort of shifted gears a bit, like many of his generation did, right, under the pressure of this decision. But I think we can look at other examples. I'm really excited by the example of, for instance, survivors of Japanese incarceration who draw lines of connection between their own histories of incarceration with other immigrant communities, right, who have been subject to family separation, child detention, other indigenous communities who share that kind of history. And I think I would love to see South Asians also kind of making similar lines of connection across other kinds of communities. And to me, again, that's part of the legacy of Thind rather than simply the kind of inheritance of this racial marking or something like that.
Yeah, I'd actually love to build on that. It's just really interesting to see that theme move forward. I feel like we all don't know enough about our history, and we need to learn the Thind case. We need to learn that the civil rights movement actually permitted us to have the freedoms and liberties that we have today in order to emigrate to the United States. And that was not something that was taught by my parents or would it be expected of them because they were immigrants. They didn't know American history. And these kinds of initiatives led by Professor Munshi to teach that kind of specific lessons is really important. But I think we continue to learn from the Thind case, and we learn what doesn't work for us as a community. And I want to point to the backlash attacks of 9/11. My community and many other South Asian communities, Muslim, Arabs, Hindus, and others, were targeted because we were perceived as terrorists, for better or for worse. And that was deeply problematic. But what we learned, because we have a community that understood that kind of, we need to stand together. And what we did at the Sikh Coalition and many other communities is we didn't say, you got the wrong guy. We're not the Muslim, we're not the Arab. That's not a framing that's correct, because that implies that your hate and violence needs to go towards someone else in the United States. And that's something that I think we're building on those threads on how can we start to figure out how to build those bonds within our own communities and even adjacent communities so that we can be stronger together rather than saying, we're higher caste than you and you don't belong to be a citizen or not. And I think this history teaches us opportunities to overcome these challenges and find better solutions together. And we have to continue to find ways to uplift some of these amazing achievements that our communities are doing as well, while also recognizing that the model minority myth also applies to us. And it risks wiping out some of the marginalization, systemic structures that minority communities continue to face even within our communities. People who are just not advantaged or privileged or weren't lucky sometimes to get to the positions that we are in today. And so to the law students here, I would certainly say, just recognize how lucky you are to be where you are today, and don't take it for granted. We've seen the appointment of New Jersey Attorney State General Gurbir Grewal, who's the first turban Sikh Attorney General in the United States for state level. But he endured a lot of hate, comments, media attacks. And it just goes to show that people want to take away what we have, whether it's citizenship or personal accomplishments or achievements, and we just can't rest on our laurels, and it's a really difficult burden that we have to continue to bear.
I guess the last thought I give is what the case draws into focus for me is, the argument was silly, right? I'm white, I found a way. And the court rejected it. And I think that the idea that stands out most to me is that and it's relevant today too, depending on, I suppose, which side of the political spectrum you sit. I sitting sort of on the lefty side of the spectrum, have never had that much confidence in the Supreme Court as sort of the place where everything's going to work out. And I think that's sort of more obvious today than it might have been 5 years ago or 8 years ago. And I think that eventually there's actually a nice-ish coda to the story. He does get his citizenship. He gets it in 1935 after Congress says that all World War I veterans, regardless of race, can apply. So he finds another way. But I think what that illustrates for me is that if you want real changes, sneaking under the door the way he tried to do in court, this is the harder path generally. The better, more durable path is make the real change that works for everyone. And so we've heard about the Immigration Act of 65, we've heard about other things that are sort of promoting good outcomes across the board. I think that that's really the project that we ought to be focused most on. And there are certainly lots of powerful ways to work on that with a law degree. I'm not suggesting that the courts have no role to play in this or that lawyers have no role to play. But I think one of the big lessons of this case to me is that it's a good illustration of how even a clever argument, thoughtfully presented, will not necessarily get us to where we need to be. What we need to be doing is changing minds about the underlying attitudes of who belongs and who doesn't.
Excellent point. Just to add to that, even in 1946 was when there was a law passed which actually allowed Indian Americans, South Asian Americans to actually naturalize, and that was really only passed through a lot of political advocacy from folks in the US, but a lot of it was based on the idea that India is becoming independent, we have to maintain decent relations with them. I think this goes back to the anti-colonial kind of perspective, right? When that anti-colonial movement was able to have some level of success, that's when all these things are kind of linked, right? When India got its independence is when the US was kind of forced to kind of change its laws as well. I think what's interesting about Thind is that later in his life too, he was supportive of these kinds of efforts. So he helped get the 1946 act into law. He also supported, for example, the Dalip Singh Sangh, who ended up being the first Sikh-American in the House of Representatives in Congress as well. So I think that's a lesson we can all learn from that today. All right, well, thank you for talking. And now we have time for a Q&A. So I think a few minutes. So anyone feel free to raise your hand and ask questions. Yes.
I'm sorry that I'm blanking on the name of the case. I think it might have been Gong Lim, Mississippi case dealing with school segregation. And I was wondering how any of you may see that as like connecting with this case in terms of Asians trying to sort themselves, figuring out how to deal with the literally black and white racial categories of America and where to fit themselves in.
So I don't know the case, but I can give you a thought on the general question. I think as time has gone on, it's become quite abundantly clear that what was a nation of only white and black and Native American people has become more heterogeneous, and that's created complications. And then there's differentiation within those groups as well, along lines of religion, national origin, and so on. I think the law has done an okay job evolving to sort of account for that. There are exceptions, you still hear about like caste discrimination, and does the law account for it? You hear about a lot about these days in like the tech industry, right? And whether it's properly dealt with by existing civil rights law. There's still debates that are being worked out. But I think that will sort of be an ongoing effort. But I think that for the most part, race relations are thought of as more complex than they previously were now. And so I don't perceive there to be, a huge issue in terms of like, I don't fit one of these two categories, therefore I don't know where I am.
Nikki Haley says that.
Yeah. Yeah, maybe not true for all of us. But that's where I sort of land on that.
I think I have a thought now about this, just having a second to think about it. I think so, during these, so after then, as I think some of you mentioned, there was a wave of denaturalization cases, right? So a number of Indians who had been granted citizenship had their citizenship challenged. Nobody was arguing that they were Black. They could have, but nobody was arguing that. And in some cases that I'm familiar with, individuals who were defending their citizenship attempted to prove their whiteness by asserting that they understood how the color line worked. And they understood that anti-Blackness was a criterion of citizenship, right? They kind of articulated that, right? And I think that's also part of the legacy of this case for us, for some of us who claim this is part of like an inheritance, right? To recognize the anti-Blackness that has also shaped Asian identity. And I think, when we think about some of like what's relevant about this case now, and we have this affirmative action case, the Harvard affirmative action case coming down, again, I think like really the task for Asian American people like us, situated as we are, I think the task is to sort of really resist being situated in the way that we sometimes are cynically situated to discipline and devalue Black and other immigrant communities too. The other thing that I don't see so much talk of now is Asian American communities, as I said, and sort of like standing up to defend border crossers, right? And others who are sometimes, who are really now the people who are most victimized by the 1965 Act, right?
Fatima?
Hi. So my question is mostly about, it's going to be a little vague, probably a rephrasing of something that Ashwin already asked, and I wasn't entirely sure I got like a clear or satisfactory response. So when you're talking about examining the legacy of this person, who was obviously like a complicated person, and we have acknowledged that some of the arguments that he made would sort of be problematic in today's context. But a lot of those arguments continue to be made in India today, where lower caste people are being lynched every day as we speak. based on those very similar sort of arguments. And today, when we are thinking about something like the Seattle caste discrimination ban law, it's there are so many groups. I mean, I know that several of you are associated with groups that supported that, but there are several Asian American and Asian groups that were sort of like, no, you should not have this. Like, this is not like, this is like anti-Asian or whatever. So I feel like when we are talking about the legacy, if we are talking about it in like overwhelmingly positive terms, aren't we sort of whitewashing all of these things? And it's not a story of just here's this incredibly interesting person who sort of tried to sneak in through the door. It's also like a story of someone who created this, like, I mean, he didn't personally create it, but you know what I mean? Like, there is like this entire chain of logic that till today continues to oppress people. And unless we take more ownership of that and maybe even denounce some parts of this legacy, how are we going to like, how is this like going to be, how is this time? I don't know if that question made any sense, sorry. I feel like I'm questioning the whole point of this panel, but
I mean, I have thoughts about this. I mean, I don't think any of us are you know, fully embrace this character. And to be, you know, I mentioned this in a correspondence today. I think the 100-year anniversary is of the case, right? I think we can distinguish between thinned man and thinned, you know, with italics and the case and what that case sort of represents, right? And I do agree with you, especially for like Indian Americans in the US. I think it's really important to sort of think about our relationship to this history, right? And to me, it's not, you know, there is no direct line of inheritance is part of what I'm trying to suggest, especially those of us who are the beneficiaries of an immigration system, the 1965 immigration system, which I don't think is itself a thing I'm to celebrate, right? I think part of what that act is remembered for is abolishing a racial bar to citizenship, abolishing, you know, the kind of like anti-Asian bar, but it also set in place, you know, criteria, like select, you know, preference categories that have favored high skill workers, right? And as you know, there is no community of immigrants that has been more shaped by the immigration policy, right? And the economic and geopolitical imperatives reflected in the immigration policy. So right now, something like 80% of the H-1B visas that are awarded to anyone in the world go to Indians, not South Asians, right? Indians. And so this immigration law has created a very specific demographic. It's pretty astonishing. It's, it's interesting that we don't reflect upon it more. It can be a little conservative. The politics of that demographic can sometimes align with some of the, the worst of what's happening, in, India at the moment, right? And I think that there is a responsibility that we have then to sort of also be aware of this, right? The way in which we have been partly kind of like a demographic created by this immigration system, and then the obligations that we might have as part of this diaspora. I don't know if that's responsive, completely responsive, but it's a great question. But do you have more thoughts about it?
Nobody else.
I just saw grimace, so that's what I was trying to figure out if there was something more there.
I think left spare time for one more question. So, Raymond, do you want to go? Yeah.
So if we go back 100 years and change the ruling and say that Bhagat Singh Thind wins, that he's like officially a white man and he can enter American society freely as a white man, would that truly have been victorious for South Asians? Like what impact would that have had? Would that impact be temporary, especially under an intersectional lens when you kind of take in classism and elitism, especially within the Asian community? Because in my perspective, Bhagat Singh Thind was an incredible person, but he also wasn't, he wasn't from like a low caste. He was a high Brahmin. He came to the US, he was able to immigrate, he was able to assimilate into American culture. So if we go back in time 100 years and actually change the ruling in his favor, what impact would that have had? And would that have been any meaningful or in any sense, or any thoughts on that?
I don't think that would have been a good outcome for the South Asian community broadly, because correctly, like you identified, his argument was based on his caste. So now you're splitting hairs between what Indians are considered white and which ones are not. And so that becomes a really interesting argument where, you know, the Supreme Court's gonna, or many courts across the country would have to start determining what caste you belong to, and then do you qualify as white or not? I think that you would have really unequal outcomes, and I don't know if that would even be sustainable, but also just like looking at like the political context in the environment, the social environment that he was in at the time, post-World War I, the United States started to wall itself off. It didn't want to accept foreigners of a certain type. So I think even if you were to see that kind of decision, there probably would have been legislation to start undoing that in some meaningful way, maybe more explicitly say, well, we don't want these kinds of people in our country. I mean, that's my imagination of like a revisionist history if that were to unfold, but I don't think that would have been a sustainable precedent to manage, because now you're just differentiating between specific kinds of Indians who are allowed to be considered Aryan or high caste white.
I don't know, it's a hard call, right? Because the counterfactual piece of it is tricky. You have to do a lot of imagining and see, you know, how do all the pieces come together. But I think what your question raises is kind of the basic argument of like, if you can't get perfect justice, do you want any benefit? Or do you want to just forego any benefit in the pursuit of perfect justice? And my own view of it is that, like, from a practical standpoint, the typical approach, especially for an attorney representing a client, is you take what's offered. Right? You get the best thing you can for your client if you're a lawyer. Right now, as someone who's not in that role, right, if you're doing your own advocacy or thinking about what a good society looks like, you don't have an obligation to a client, you should feel free to see it very differently. So I think like a lot turns on the lens you bring to it, but that does seem to be the basic question you're asking, right? Is like, if this guy could have gotten his citizenship and as a result had a situation where you wouldn't have a wave of denaturalization proceedings against a couple of, you know, few dozen other people immediately, and then there were a couple thousand affected down the line, right? Would that be worth it to enshrine a precedent that basically says this guy gets to stay because he's white, right? Which you regard as like an off-putting line of reasoning. It's almost impossible to weigh it in any coherent way. And so at the end, I think it comes down to like what feels good in your soul about it. But I will say in the real world, what tends to happen is compromises get made at some point, right? I'm unaware of progress being made in sweeping and bold terms that everyone is always happy with everything.
Thank you. Well, thanks everyone for your questions, and let's give all the panelists a round of applause. And before we end, I want to invite Ravi from Sabha DC to make a few remarks.
Well, first of all, thank you all for coming and to have a Sabha DC, to have our president have to lead early. We really appreciate Ashwin for really taking the lead on this. And Sabha DC is proud to partner. This is a series that we did the 95th anniversary. So this being the 100th anniversary, Sabha DC is proud to have partnered with Georgetown and Ashwin specifically for leading this. Sabha DC continues to do a variety of programming and a variety of topics such as the South Asian relations with the anti-blackness movement. Professor Munshi mentioned we have that in a couple of weeks. For all the students, Sabha DC offers free membership for law students. So I encourage you to join, if not join the organization, to look for our newsletter and other programming, and frankly, to suggest programming that we could do that are of interest to the South Asian and broader legal community. Please do reach out to us via our website or to us, myself and Kirti are on the board at the reception to follow or any time, so we can be do programming that is responsive to the needs of the community. And thank you all for doing this, and thank you to Georgetown University for inviting us and letting us partner in this great venture. Thank you.
Thank you.